Ladies and gentlemen, welcome to this BUL International Law Group seminar and event on Indigenous peoples and international law, a topic that is not touched very often, but is crucial to the development of international law and is aligned to many other themes also of international law, like the right to self-determination, land issues, property law. And along these lines, we have a line of important speakers together. We have the pleasure also to host with us two Brunel University London colleagues. The one is Dr. Colin Luoma, who is going to chair also the event and wage a discussion. And we have also, together with us, the UN Special Rapporteur on Cultural Rights, Professor Alexandra Xanthaki, who is also from Brunel University London. So the pleasure is double today. The event is going to be waged like this. Now the podium is going to be passed to Dr. Luoma to introduce the speakers, and of course a bit Professor Xanthaki for those of you who may not know details of her academic path so far. And afterwards, after the speakers and the discussion takes a form here, you, people of the audience, will have an opportunity to raise your questions in written through the Q&A section that you see here in the Zoom room. So not in the chat, but send your questions in the Q&A section. To remind you that the event is being recorded, the video is going to appear in the Brunel Law School YouTube channel, so you can subscribe also there in order to follow us, also to see previous videos of the other events we have hosted. With this, I pass the baton to Dr. Luoma, who is going to be the chairperson of today's event.
I'm just getting something from Professor Xanthaki that says there's a problem with the audio. Can everybody hear okay? And the speakers seem to suggest that that's okay. So let's see how it goes, obviously, and we can try to address it if it flags up again. But
Professor Xanthaki, you have to unmute yourself also, if I can notify this.
Sure. Great. Well, thank you, Dr. Solomon, for officially getting us started today, and welcome everyone to what I'm confident will be a very interesting and engaging webinar. I am especially grateful considering how busy of a period it is for most of us. I'm really honored to be able to chair this afternoon's panel on what is a wide-ranging and constantly evolving subject of international law, which is Indigenous peoples' rights and international law. And I'm certainly not going to spend much time talking because I want to be brief, because I want all of you to have as much time as possible to hear from the incredible group of experts that we have assembled here today, all of whom I can confidently say are doing really brilliant work on the forefront of the field. There is no doubt that international law has evolved considerably in the past decades to increasingly recognize and protect Indigenous peoples' rights. Yet Indigenous peoples still face immense challenges. And as scholars and practitioners, we're still grappling with how exactly international law can and should respond to these challenges. And luckily, here we have some speakers who are able to engage with some of these issues, shed some light on a few of the things that have been accomplished, and perhaps comment on some of the inevitable hurdles that lie ahead. Each, like Dr. Solomon said, each of the panelists will have approximately 15 minutes to make their presentation. And then our own Professor Xanthaki has graciously agreed to offer her own reflections, comments, questions at the end of the presentations. And then we'll open it up to the Q&A. I'll monitor the Q&A function to make sure to bring those into the conversation the best I can. So with that, I want to turn to our first speaker, who's Dr. Rauna Kuokkanen. Dr. Kuokkanen is a research professor of Arctic Indigenous Studies at the University of Lapland and an adjunct professor of Indigenous Studies and Political Science at the University of Toronto. Among other things, her research focuses on comparative Indigenous politics and law, Indigenous feminist theory, Arctic governance, and settler colonialism. Her latest book, Restructuring Relations, Indigenous Self-Determination, Governance and Gender, published by Oxford University Press, won multiple prizes, and we are so very lucky to join us or have her join us today. And as I mentioned earlier, we only have Dr. Kuokkanen for the first 40 minutes or so of the panel today. So maybe we'll take a quick break and look if there's anything in the Q&A specifically for Dr. Kuokkanen so that we're able to engage with her presentation before she has to leave us today. So with that, I'm turning it over to Dr. Kuokkanen.
Ollu kiitos. Thanks so much, Dr. Luoma and Dr. Solomon and Brunel University Law School for the invitation to this panel. And thanks so much for accommodating my unexpected obligation and also the Q&A if there are any after my talk. It is my pleasure to join this panel on Indigenous peoples and international law. Like Dr. Luoma said, that it's a burgeoning field, but there needs to be more panels and arenas like this to discuss this also in the European context. So I really appreciate the invitation. In my talk, I focus on Indigenous women's rights and international law, particularly vis-a-vis the UN Declaration on the Rights of Indigenous Peoples. Are Indigenous women's rights protected in international law? As Indigenous people, Indigenous women are ensured the rights enshrined most explicitly in the UN Declaration on the Rights of Indigenous Peoples, or the UNDRIP, since 2007. The UNDRIP represents globally endorsed minimum standards and an important normative framework of the rights of Indigenous peoples founded on international human rights law. As women, Indigenous women are assured the rights contained most notably in the Convention on the Elimination of All Forms of Discrimination Against Women, the Women's Convention, or CEDAW as it's sometimes called, from '79. In spite of these two key international human rights instruments, Indigenous women's rights remain an overlooked issue both at international and national levels, not to mention local levels as well. So in my talk, I ask whether the Indigenous human rights discourse reproduces and perpetuates similar exclusions and hierarchies towards Indigenous women that international law is regarded to maintain toward women in general. At the end of my brief remarks, I consider the Zapatista women's revolutionary law as an example of an explicit expression of Indigenous women's rights developed by grassroots Indigenous women. I juxtapose it to the UNDRIP and ask how the declaration would have been different had it taken the revolutionary law seriously, and therefore contributing to a fuller and more comprehensive and effective recognition of Indigenous women's rights in the international human rights discourse. Feminist human rights experts have long argued that universal human rights standards are in fact men's rights, as they are based on male as the norm. These rights are primarily concerned with human rights violations that occur in the public sphere, such as state violence to the exclusion of most gender-based violations faced by women. As Catherine McKinnon puts it, human rights have not been women's rights, not in theory or in reality, not legally or socially, not domestically or internationally. When violations experienced by women are unlike those experienced by men, they are commonly overlooked as human rights violations. The UNDRIP is widely considered to be an instrument which balances between individual and collective human rights of Indigenous peoples and which recognizes the full compatibility between the two. A lot has been said and written about the content, meaning, and implications of the collective rights enshrined in the declaration, but individual rights contained therein have thus far received much less attention. 10 of the 46 provisions enshrine individual rights, 7 of which fall under the category of political and civil rights. Indigenous women are mentioned in 3 of all provisions. Articles 21 and 22 urge states to ensure the protection of the rights and special needs of Indigenous elders, women, youth, children, and persons with disabilities. Moreover, Article 22.2, considered to be the most important provision with regard to specifically safeguarding Indigenous women's rights, calls for states to ensure that Indigenous women and children enjoy the full protection and guarantees against all forms of violence and discrimination. And finally, Article 44 states that the declaration applies equally to male and female Indigenous individuals. Besides these three articles, the language of UNDRIP is gender neutral, and it does not elaborate what the rights and special needs of women or the other aforementioned groups might be. So aside from Article 22, the only individual rights in the UNDRIP outside the civil and political realm pertain to health. In other words, the UNDRIP is largely formulated to protect civil and political rights in the public sphere, a sphere which continues to be dominated by Indigenous men, at least in most parts of the world. For example, the right to be free from discrimination with regard to labor, employment, and salary can be interpreted to pertain only to work in the public realm. The work and economic activity within the domestic or private sphere, commonly performed by Indigenous women, is rendered invisible or not even considered work. There is, however, an area of civil rights that are pertinent to Indigenous women, but is not addressed in UNDRIP. That is sex or gender equality rights vis-a-vis the right to a membership or citizenship in cases where either Indigenous governments or state legislation are the human and civil rights violators. And perhaps most well-known example from Canada, where, for instance, civil and political rights that Indigenous women have had are founded on their traditional roles and responsibilities and are supported by Section 35.4 in the Constitution, in the 1982 Canadian Constitution. There are also examples where Indigenous women have employed the equal protection provisions of applicable civil rights legislation in cases of gender discrimination in the membership codes of their own communities or nations. A common critique by Indigenous women of the international women's movement suggests that focus on gender discrimination tends to overemphasize individual equality and rights rather than the effects of structural violence on women's lives. For example, the International Indigenous Women's Forum, or FIMI, as it's known for short, argues that, quote, flawed assumptions that operate within the global women's movement make the movement's strategies of addressing gendered violence inappropriate for Indigenous women. Indigenous women have long advocated for human rights framework that addresses gender-specific human rights violations of Indigenous women in such a way that does not disregard the continued practices and effects of colonialism. The Beijing Platform for Action, emerging out of the Fourth World Conference on Women in 1995, for example, was criticized by many Indigenous women for its overemphasis on gender discrimination and gender equality, which, according to FIMI, does not recognize the special circumstances of Indigenous women, and which also depoliticizes issues confronting Indigenous women. No doubt there is an overemphasis on gender discrimination and individual equality rights within certain fields of feminist theory and activism, especially within a liberal feminism and its equality of opportunity approach that revolves around gender equality with and equal rights between men and women, particularly in the public sphere. The narrow liberal feminist focus on gender discrimination in the public square or sphere has also been criticized by many feminist legal scholars who have argued that to move beyond the limited approach of non-discrimination in women's human rights law requires defining rights that are specific to women and attend to specific obstacles women experience. And these include, for example, or most clearly reproduction and childbirth, minimum wage for domestic and subsistence work, and literacy. Why did not UNDRIP include these rights in its provisions? For instance, considering the significance of family in its various forms for Indigenous peoples, like extended families, kinship relations, clans, and many other forms, it is surprising that it did not include rights associated with reproduction and childbirth. Identifying and including rights that are specific to Indigenous women and attend to specific obstacles Indigenous women experience would have only strengthened the UNDRIP and made it even more groundbreaking instrument within international law than in its present form. The UNDRIP's emphasis on civil and political rights rather than human rights in the private sphere, or balancing the both, may also stem from a widely held view in international law and at the state level, according to which oppression on the basis of race is considerably more serious than oppression on the basis of gender, reflected, for example, in the fact that the Women's Convention, the CEDAW, contains much weaker implementation mechanisms than the Race Convention, or the Convention on the Elimination of All Forms of Racial Discrimination. Indeed, some women do consider oppression and discrimination of Indigenous peoples as peoples more pressing than oppression of Indigenous women. The situation whereby the feminist movement overemphasizes gender discrimination and Indigenous movement focuses on colonialism reflects the failure of identity politics to attend to intra-group difference or oppression. As a result, the rights of Indigenous women remain in the shadow and unaddressed by key documents and instruments like CEDAW and UNDRIP. In my concluding section, I consider the rights enshrined in the Zapatista women's revolutionary law and ask how the UNDRIP would have looked different had it included key insights formulated by Indigenous grassroots women themselves. The Zapatista women's revolutionary law from Chiapas, Mexico, is one of the very few existing explicit articulations of Indigenous women's rights today. As a whole, Indigenous women represent one of the most revolutionary forces in Chiapas. Women have called attention to the lack of harmony in gender and power relations within their communities and introduced critical perspectives, particularly to those traditional customs that degrade, oppress, or marginalize them. As a result, these women are not always met with open arms. The challenges experienced by Zapatista women in their communities, but also within the Zapatista movement, led to the creation of women's revolutionary law. This 10-point list, accepted by consensus at the EZLN meeting in March 1993, stipulates women's rights to education, equal pay, and equal participation and leadership. The laws also oppose forced marriage and denounce male physical and sexual violence. The Zapatista revolutionary law, women's revolutionary law is a well-balanced document with a double emphasis on political participation and leadership on the one hand, and the right to individual autonomy and the right to be free from all violations of personal integrity and human dignity on the other. It indeed could be considered an embodiment of the ideal of the indivisibility of women's rights, enshrining both civil and political, in other words, the public rights, as well as the protection of human rights violations that are usually gendered and considered private. In addition, the Zapatista women's revolutionary law explicitly enshrines women's reproductive rights, something that the declaration remains silent on. Likewise, individual autonomy and integrity of women, the right to choose their partner and not to be forced into marriage, are not included in the UNDRIP. As the UN expert group meeting on violence against Indigenous women discussed in 2012, forced marriages continue to be a reality for many Indigenous women in the world. Some rights articulated in the Zapatista women's revolutionary law are also enshrined in the UNDRIP: the right to work, the right to health, and the right to education. However, UNDRIP does not specify any of these rights in gendered terms, nor address the often disparate access to work, education, and health services between Indigenous men and women. There's another critical dimension to the right of Indigenous women to work and just salary, a dimension that distinguishes it from a general recognition of the right to work. And that is the pressing need to ameliorate Indigenous women's socio-economic circumstances in a way that alleviate their poverty and hence circumstances that give rise to violence. The Zapatista Women's Revolutionary Law recognizes this implicitly by enshrining the right of women to work and just salary, the way that UNDRIP doesn't. Discussions of literacy, education, and poverty are necessary to any consideration of Indigenous women's rights in general and elimination of violence against Indigenous women in particular. Indigenous women often have more limited access to education as well as health services as men in their communities. Why were the unambiguous, well-formulated provisions contained in the Zapatista Women's Revolutionary Law not integrated in the UNDRIP, considering that the laws were passed in '93? It was, or they were formulated in '93 and made public in '94, well over a decade before the UNDRIP was adopted in 2007. The core principles reflected in the Zapatista Women's Revolutionary Law have already been enshrined in existing human rights law, such as CEDAW, or in particular CEDAW. So in my view, including the provisions articulated in the revolutionary laws would only have strengthened UNDRIP. And I also argue further that it would have resulted in a radically more comprehensive human rights instrument for Indigenous peoples, which would have been more profoundly attuned to the ideal and objective of the indivisibility of Indigenous people's rights, individual rights and collective rights, and which would have moved beyond the public-private hierarchy and the standard practice of privileging civil and political rights found in the international human rights instruments. Thank you very much for your attention.
Great, thank you very much for that presentation. Really, really important intervention with much to reflect upon, particularly with shortcomings with the declaration with respect to Indigenous women. I realize that Professor Xanthaki is still having login sound issues, so she's going to log back out and jump back in, hopefully. But I wanted to just take a quick break here because we only have Professor Kuokkanen for a brief period of time. So I wanted to just check with the other panelists and Dr. Solomon to see if they had any questions before we move on. And also, if anybody in the audience wants to ask a question, please pop it into the Q&A so that we can pose it to Dr. Kuokkanen before she has to leave.
Actually, Dr. Luoma, since the audience now is thinking maybe, and there will appear some questions in the Q&A, and before also the other panelists voice their opinions, I have a question to Dr. Kuokkanen. We spoke about, of course, the discrimination that indeed happens against women. My question is, does it vary according to the areas of the globe? Because we have Indigenous people all over the globe, from Japan to Lapland to Mexico, and you refer to the Zapatistas. What are your conclusions? Is the discrimination against women the same in nature and in intensity all over the globe when it comes to Indigenous people?
Obviously, not in terms of intensity, but the foundations, like it is clear that, say, the structural oppression and kind of not only the legacies of colonialism, but ongoing colonialism has continues to impact Indigenous women globally. But the effects, like the concrete manifestations, are different. And in areas of conflict and war, obviously, violence is much bigger problem, but they are still issues, like there aren't statistics or like detailed data from all Indigenous regions or Indigenous groups or peoples in the world in terms of gender-based violence or violence against Indigenous women, but the information that we have, the data that we have, shows that Indigenous women do experience violence, gender-based violence, at the greater numbers than non-Indigenous women in their regions. So the issues are same, but the intensity differs.
If I can follow up a bit to this thought and question, does the fact that the state is in war or not, for example, Mexico, there has this armed conflict with Zapatistas, affect the intensity of the violence? Or for example, in Lapland, where Finland is it's a state in peace, do we have lower rates of violence against Indigenous women?
Of course, like when we talk about violence, we talk about a whole range of violence. We talk about state violence, structural violence, interpersonal violence. So, for instance, Sami women living in northern Finland, for instance, they don't experience the same level of state violence. You could argue that there is no state violence to a degree that Zapatista women are currently and have been experiencing for the past several decades. So yes, of course, there are differences, but we have to remember that kind of like the scale of violence is very broad, and yes, state violence is much worse, or in some parts of the world, and perhaps next to non-existent in others. But for instance, up until very recently, there was this understanding that Sami women do not experience the same or do not experience interpersonal violence disproportionately like many other Indigenous women. But there's recent research shows that that is not the case, that also Sami women experience greater degree of interpersonal violence. And it came as a surprise to many and has been taken seriously by the Sami political institutions as well. Thank you for that question. Very important one.
If I may abuse my position as the chair and ask a question that I think would be interesting to get your perspective on, in the sense that I've noticed that there is a growing reliance, maybe not reliance isn't the right word, but a growing movement to use various tools of transitional justice, including Truth and Reconciliation Commissions in the Arctic, to address historical legacies of violence against Indigenous peoples. I'm just curious if you're following that at all, and if so, what should we expect with respect to how those mechanisms are ensuring adequate women's governance, their participation in leadership in the design of those mechanisms, or whether, like perhaps some of the Canadian commissions, that might be another shortcoming where an international tool is falling short of respecting the rights of Indigenous women. I didn't know if you had any thoughts on that.
Thanks. Another very timely and important question. Yes, I have followed. I lived in Canada through the TRC process there, and it was certainly very interesting to follow that. And as we know, there's some scholarship on it as well, that it largely failed to consider Indigenous women's rights violations specifically. So it didn't have a gender approach. And of course, that is problematic because it doesn't, like the final report does justice to violence in general, but it doesn't, when you don't consider how this violence is gender specific, a lot of the detail, but also the policy recommendations fall short. And the same here, in the Nordic countries, in Norway, the TRC process has proceeded furthest. I don't think they are paying much attention to this question either. And as we know from research, that if we don't take gender seriously, then also the solutions and the policy is inadequate. Like, it does not address the specific issues. So, and for sure, to your question about Indigenous women's leadership, that's something that is lacking. The indigenous GRC processes that I'm aware of, it has not been in the forefront in any of them.
Thank you very much for that. Ms. Dominguez, I see your hand. Maybe we'll take a question from you, and then we have one in the chat, and then we'll have to quickly move on to hear from our other speakers. Go ahead.
Thanks. It was a super interesting presentation, so thank you for that. I just had a question about, using intersectionality and intersectional discrimination as a lens to think through some of the sort of standards used in typical discrimination cases to redress the intersectional discrimination that a lot of Indigenous women face. And in particular, as a conceptual framework for decision makers and lawmakers and judges to think through some of the challenges that continue to face Indigenous women today.
Absolutely. And it's something that I've discussed elsewhere, that's the approach that we all should be embracing and thinking through, and even like making it more, I guess the challenge is like I mentioned it briefly, that there's this kind of discrepancy that Indigenous rights focus on race-based or prioritize race-based oppression, and then women's rights, human rights framework and law obviously emphasizes gender. And then sort of Indigenous women fall through the cracks because there is no expertise, there's no skill, there's no broader understanding of that necessity of the intersectional approach, that without the intersectional approach and intersectional understanding, these Indigenous women's rights remain in the shadow. They are not taken into consideration. They are not even on the radar. They're not on the agenda because they are recognized as something that need specific attention. So like, in other words, there's like much greater need also in terms of training. When we talk about Indigenous rights in law schools and teach Indigenous rights in law schools, we should always have that kind of intersectional lens on these issues.
If I may, I'm just going to bring in one final question from the Q&A, and then we can move on. But Helene asks, how do Indigenous women scholars relate to these issues of gender discrimination in international law? I don't know if there's a way to answer that in a brief comment, but.
In a brief comment, I think it's worth, and I and others have written about it. There is an increased consensus on the need to have discussions on, like, have scholarship, to have a framework specifically focusing on gender discrimination or gendered violations pertaining to Indigenous women globally. There are others. There are some like in scholarship, perhaps not so much anymore, as there is also as the result of global movement of Idle No More and the Standing Rock, where Indigenous women have been leading and taking leadership positions. So I think there is a greater recognition of the fact that Indigenous women's rights need to be addressed head on, and not as add-on to Indigenous rights in general, but placed up front, right front and center of discussing Indigenous people's rights in general. So if you do that, then that kind of intersectional approach will stay also, or the focus is on the intersectionality of these rights when Indigenous women's rights are placed up front. So, and I discussed this in my book as well, that when we talk about Indigenous, the most recent book that Dr. Luoma mentioned, that there's this kind of general, at least the Indigenous women that I spoke to in 3 different continents or jurisdictions, that when we talk about self-determination, we need to place the roles and responsibilities and also the political positions of Indigenous women at the center. And because if we don't look at the issues that are faced, that Indigenous women face specifically, then we are kind of excluding those issues and Indigenous women from discussions of implementing self-determination, that we cannot talk about self-determination without talking about gender justice.
I think that's a great way to wrap up this this part of the discussion. I just want to thank Dr. Kuokkanen for being here with us today. I know that she needs to run, but we will continue the conversation, obviously, and if we can turn to our second speaker, who is Dr. Dorothee Cambou. Dr. Cambou is an assistant professor of sustainability science at the Faculty of Law at the University of Helsinki, where her research focuses on, among other things, Indigenous people's rights, land and resource governance, self-determination, environmental, social justice, etc. She's currently the co-chair of the Nordic Network for Sami and Indigenous Peoples Law, and she has multiple research projects in the pipeline focusing on Indigenous people's rights and sustainability. So if I may pass the mic to Dr. Cambou, the floor is officially yours.
Thank you very much. I have to say it's a pleasure to be here, also among those other great panelists. And it's specifically a pleasure to discuss the issue raised by the relation between Indigenous people and the international law, because as I shall argue in my presentation, it's rather a conflicting relation. But as I begin this presentation, I must say that the timing for this event is in fact right. Because if I had made this presentation a few months ago, I certainly would have started my presentation by expressing my deep frustration with international human rights law. In fact, I would have probably asked other questions, such as whether international law matters at all to protect the right of Indigenous people. I would have questioned whether international law is really taken seriously by our governments. And finally, I would have asked whether Indigenous representatives and human rights activists should stop wasting time trying to litigate against the government and companies affecting their rights, especially as we see, because national courts too often neglect or silence those claims. But today I'm here to discuss the decision of the Supreme Court of Norway in the Fosen case. And this, as we shall see, has reactualized the significance of international human rights law in protecting the right of Indigenous people. And I think this court case insufflates some hope, but also confirms some old uncertainties concerning the conflicting relation between Indigenous people and international human rights law. So against this background, the underlying question I'm targeting today with this presentation is what the significance of human rights law is to protect the right of Indigenous people. And I will examine these questions through the lens of the Fosen case. In this presentation, which is rather short, I will focus on two core issues, which are concerning basically the human rights to culture and the human right to a healthy environment. But before I speak about those rights, let me first circle back to the Fosen case. What is the Fosen case about, and what is the Fosen project about? The Fosen project is nothing less than the largest European wind energy project. The project counts 277 turbines, which are divided among 6 wind farms, including the most controversial one, Storeia and Rhone wind farms. The project construction was completed in 2020, and it's a project that is owned by a public-private venture, since it's partly owned in majority by a national and municipal energy companies, as well as Nordic Wind Power, which is a European consortium founded by Credit Suisse. And with its 277 wind energy turbines, the project was expected to double the wind production from Norway. So as such, the project is considered instrumental for the so-called green shift. It is located in central Norway, where the wind conditions are excellent, but also more problematically, where the traditional land of the South Sami community is located. And an important remark at this stage is also that the South Sami community represents a minority within the minority Sami indigenous people. It has been noted that their language is listed by UNESCO as endangered, and their traditional livelihood, which includes reindeer husbandry, is also under pressure due to the competing land use, such as those caused by the fossil wind energy projects. So despite the Sami opposition to that project, both the Energy Directorate and the Ministry for Energy in Norway decided to support the construction of the Fosen project. At the time, the main argument was that the impact of the project did not constitute a threat for reindeer husbandry and therefore did not imply a violation of human rights. The Sami communities, together with environmental activists, contested those conclusions and opposed the project in the street, in national courts, and at the international level by petitioning the Committee on the Elimination of Racial Discrimination. And in fact, the committee requested in Norway in 2018 to suspend the construction of the project. But the ministry gave the go-ahead for the project nonetheless. Which at its stage, I would say, certainly raise question about how seriously human rights treaty body requests are taken into account by governments. But in the meantime, the license decisions were also appealed by several organizations at the national level, but the wind turbines were nevertheless built and put into operation after the ministry gave its consent to start the development. So fast forward to the Court of Appeal decision in 2019, the Court of Appeal established that the wind farm threatened the very existence of reindeer husbandry on Fosen. However, this was still not considered a violation of Article 27 of the ICCPR, because the Court of Appeal found that it was possible to introduce winter feeding for the reindeer as a measure to mitigate the impact of wind farm. Importantly, however, the Court of Appeal mentioned in its decision that it had doubts about the impact of winter feeding and its compatibility with Article 27. In fact, reindeer herders themselves have argued that such a measure is in violation of human rights because it is not in accordance with their traditional practices and have a negative impact on the welfare of the reindeer. Yet, the Court of Appeal, with its doubts, validated the licenses for the construction of the Fosen projects. So now, in 2021, I must say that it took most of us by surprise when the court in its grand chamber ruled unanimously that the licenses for the Fosen project were in violation of Article 27 of the ICCPR. I assume until now that all of you are already familiar with this provision, but let me mention again that Article 27 of the ICCPR is the only universally applicable provision that protects the right of the member of a minority group to culture in a binding way. In effect, however, this provision has been extensively interpreted as providing also protection for the cultural right of indigenous people, including their traditional livelihoods. As a result, the right of the Sami people to reindeer husbandry is protected by Article 27 of the ICCPR. And in Norway, what must be also noted is that the provision has a specific importance because the ICCPR is incorporated in national law, which means that Article 27 takes precedence over national legislation. But yet, despite this protection, the fact remains that there is no judgment that has ever established a violation of the right of the Sami people in Norway based on Article 27, at least until the Fosen decision. In that regard, the Fosen decision stands as a landmark decision under national law in Norway. But in addition, my argument today is that the Fosen decision is also important for the development of international human rights law and the right of indigenous people, because it provides some clarification about the interpretation of Article 27. As mentioned earlier, I will focus on two main issues in that regard. First, I will focus on the court statement regarding the cultural right to reindeer husbandry. And second, its finding regarding the human right to a healthy environment. So in practice, what were the decisive elements that led the Supreme Court in Norway to establish a violation of Article 27 of the ICCPR? Well, first, in its decision, it's important to note that the Supreme Court agreed with the assessment of the Court of Appeal that the impact of the Fosen project constitutes a threat to the existence of reindeer husbandry. Second, but in disagreement with the Court of Appeal, the court decided that mitigation measures in the form of winter feeding were not compatible with Article 27. The court concluded that there were too many uncertainties concerning the impact of winter feeding, and in its decision, the judge indicated that winter feeding is a practice that is so remote from traditional reindeer husbandry that it may conflict with a cultural practice. In effect, what we see is that by providing winter feeding, reindeer herders are forced to keep reindeer in an enclosure, which goes against the traditional cultural practice. Although the court did not conclude that winter feeding is per se in violation of Article 27, it concluded that the issue has not been given a broadened and thorough assessment by the government, and general reindeer husbandry interests had not been heard. So the importance given by the court to the need of adopting mitigation measures that are culturally appropriate may seem obvious. However, while looking at previous decisions, both in Norway and Sweden, it is striking to see until now that neither the government nor the court have fundamentally challenged whether licenses should be rejected because of their inadequacy in relation of Article 27. However, as indicated by the Supreme Court, those mitigation measures are problematic, and this for two main reasons. First, because those measures are too remote from the traditional practices used by some Sami reindeer herders, but also second, because there is little knowledge about the potential effect of those measures on reindeer. So on that count, I think it is also notable that the court did not delve further into details regarding the implementation of the duty of the state to consult indigenous people. And in that regard, my argument would be that the Fosen project was in fact authorized in opposition with the principle of free, prior, and informed consent. However, this is not something that the court further elaborated upon. This said, the fact that the Supreme Court found at the end a violation of human rights provides a new precedent to address the conflict between wind energy and reindeer husbandry in future cases. But retrospectively, the case is also interesting because it raises the question to know whether other wind energy projects in Norway or Sweden have been authorized in violation of the cultural rights of the Sami people. So ultimately, to measure the importance of Fosen, we must therefore wait and see how the decision will affect the decision-making of licensing authorities and future court decision in order to see how the Fosen will have significance, Fosen decision will have significance or not. But in addition, I also wanted to say a few words about the finding of the court regarding the human right to a healthy environment and its relation to the right to culture. Indirectly, the Fosen case raised the question to know whether climate emergency and the promotion of renewable energy should trump the human right to culture. In other words, the question raised by the Fosen case is, should the public interest to promote renewable energy in addressing the climate crisis override the interest to protect the human rights to culture? In its decision, the court agreed that the green shift and the production of renewable energy are crucial consideration. However, the Supreme Court recalled that Article 27 does not allow for balancing of interest. In other words, and additionally, the court also disagrees that the Fosen case raised the conflict between basic human rights, which would entail balancing the right to culture with a human right to a healthy environment. In fact, the court concludes that the government of Norway could have taken less intrusive development alternatives to ensure that the protection of the cultural right to practice reindeer husbandry is protected. This is an important finding because it reminds us that climate emergency is not a trump card that could justify a violation of human rights. The decision of the court also indicates that the human right to a healthy environment should be interpreted in harmony with other human rights and cannot be used as a justification to undermine the protection of other rights, including those of indigenous people. In other words, and in short, the ends does not justify the means. But by way of concluding this presentation, let me circulate back to my introduction and the question of the significance of the Fosen decision and more generally human rights law in protecting the right of indigenous peoples. Based on this presentation, I will make two final but dual points. First, the decision of in the Fosen case is a landmark decision because it has established a violation of the right of indigenous people. It is therefore also significant for the development of human rights law because it provides a precedent to clarify the interpretation of Article 27 of the ICCPR. However, from a more empirical perspective, the decision is also negatively emblematic because it demonstrates that Norwegian law remains unfit for the purpose to protect the right of indigenous people. The Fosen decision, on top of it, came too late for preventing the violation, since the Fosen project was already completed when the court decision came out. Finally, it is also striking to see that since the decision, the government of Norway has not come up yet with a proper solution to remedy that violation. As a result of this, I will conclude that the significance of Fosen for the protection of the right of indigenous people is yet to be further established. Ultimately, we face the hard reality that the significance of human rights to protect indigenous people depends on the extent to which national authorities decide to give them significance. In other words, international human rights law only gains significance when business, governments, and the court takes them seriously into account. Hence, the conflicting relation between indigenous people and international human rights law. Thank you for your attention.
Thank you very much for that excellent talk and for providing such clear legal analysis on the Fosen decision. Not only that, but we have reason for some cautious optimism with a rare legal victory for indigenous peoples. So it's great to hear. I'm sure there'll be plenty to follow up later in the discussion here. But I would like to turn immediately to the next speaker in the interest of time, and then we can group all the questions at the end. So with that, we have the opportunity to talk to a litigator after talking about a litigation case. Lara Dominguez is currently the Strategic Litigation Officer at Minority Rights Group International, which is a prominent human rights NGO focusing on the rights of indigenous peoples and minorities. Lara is actively litigating indigenous land rights cases, both before the African Court on Human and People's Rights and the African Commission on Human and People's Rights, and has made various legal interventions in other regional human rights courts, as well as UN treaty bodies on behalf of minority and indigenous communities. So with that, I'm very happy to pass the mic to Ms. Dominguez.
Well, thank you, Dr. Luoma and Dr. Solomon and Brunel University in general for hosting this panel, and also the co-panelists. This has been, I was really excited about joining everybody today to speak. And actually, I think that Dorothee's presentation strikes on one of the issues that I talk about in my presentation, which is the non-implementation of indigenous rights more generally, and how damaging that is, and how it's a real challenge that we have to overcome, and that I don't think is just relegated to the realm of indigenous rights. I think it's a general crisis in human rights law generally, which is the non-implementation of international legal provisions that have been ratified by states, and how we as practitioners, but also as the broader global community, plan to try and overcome what is a major challenge in human rights work more generally. So with that, I guess I'll start by giving a brief sort of preview or structure of what I plan to discuss today, and then just sort of dive in. So I thought it would be helpful to just give a brief overview of indigenous rights in international law and its significance, then cover some of the challenges around implementation of these protections by states, and then talk about a specific case study, if you will, but looking at specifically non-implementation of Indigenous people's rights in the realm of conservation. And then finally, sort of conclude the presentation with potential ways forward. Although this problem is pretty intractable, so I'm not claiming to have a solution, but just to kind of think through or invite us all to think through how we might overcome this challenge. So starting with the basic overview of Indigenous rights under international law, by way of background, basically, despite the move towards decolonization following World War II and the adoption of post-war human rights instruments that have come to define the international human rights regime, such as the ICCPR and the International Covenant on Economic, Social, and Cultural Rights, by the 1970s, Indigenous peoples were deeply frustrated by what they saw as an incomplete decolonization, continued discrimination vis-a-vis the non-recognition of their specific rights under the corpus of international human rights law, and ongoing rights violations by states following decolonization, including through breaches of nation-to-nation treaties that had been agreed to by states and Indigenous nations. So this sort of, I guess, frustration with the status quo is what led to the rise of the global Indigenous movement as we know it today, and decades of advocacy by Indigenous peoples themselves at the international level, and in particular before the UN, which eventually led to the adoption of the UN Declaration on the Rights of Indigenous Peoples by the General Assembly in 2007. It's one of the global Indigenous movement's biggest achievements, and it's significant for a number of reasons, which have been touched upon or gestured at by some of the previous panelists, but I'm quickly going to recapitulate here. So one of the things is that in some senses, it reimagines Westphalian politics because it reestablishes the relationship of the individual to the state. In some senses, it recognizes collective rights. And it's the first time that the individual rights bearers themselves participated in the negotiations that eventually led to the adoption of the text of the UN Declaration on the Rights of Indigenous Peoples. And even though it's a non-binding instrument, which states often in my negotiations with them, often underscore, the fact is that it establishes the minimum standards under existing international human rights law, including international binding treaties that a lot of these states have ratified, whether it be the ICCPR, the International Covenant on Economic, Social, and Cultural Rights, or any of the number of regional human rights treaties, in particular, for example, the American Convention or the African Charter on Human and People's Rights. So even though people claim it's non-binding, in practice, the way that the law is interpreted and applied by decision makers makes reference to those standards. And therefore it operates as a benchmark against which to assess state practice. So it's useful both from an advocacy perspective, but also from a litigation perspective. And I'm just quickly going to go over some of the key provisions. So, or principles that are enshrined in the declaration. So it provides for individual and collective rights of Indigenous peoples. It recognizes Indigenous peoples' right to self-determination, land and resources, and the right to free, prior, and informed consent. It emphasizes Indigenous peoples' rights to exist, to maintain and strengthen their own institutions, cultures, and traditions. It prohibits discrimination against Indigenous peoples while simultaneously affirming their right to remain distinct peoples and to pursue their own vision of development. And it recognizes Indigenous peoples' rights to identity, language, health, education, and a host of other rights. And as I mentioned, there's important jurisprudence, both at the regional human rights level, but also at the international level of UN treaty bodies that recognizes these rights. And as Dorothee was mentioning, domestic courts increasingly are making reference to Indigenous people's rights and the standards that are articulated in the declaration. So I guess having said that and having recognized the progress that has been made, I think the biggest and most challenging issue, both for Indigenous peoples, Indigenous activists, and the lawyers who are representing or taking on Indigenous rights cases is despite a growing body of precedents and judgments that recognize Indigenous people's rights, at the end of the day, a lot of the time, these judgments are not being implemented. The same is true with advocacy that has been done at the domestic level to prod states to adopt domestic legislation formally recognizing the protections enshrined at the international level for Indigenous peoples. One example is, for example, Kenya, that has at least, although not formally recognizing Indigenous peoples, at least a framework through which they can begin to articulate their rights, and in particular community land rights. And that act of legislation remains ultimately unimplemented. So you're seeing a lot of the non-implementation trickle down even at the level of once this legislation is adopted domestically, it's still not being implemented in practice. And I think at the heart of why this is the case is ultimately the power dynamics that still need to be overcome. A lot of that discrimination that Indigenous peoples continue to face is reflected in that non-implementation of their rights and the unequal power dynamics that are at play that ultimately end up impacting reality on the ground to this day. So I'm going to briefly talk about some of the cases that MRG has and that MRG has litigated on behalf of Indigenous peoples and that continue unimplemented. So there's the Android case against Kenya, which was successfully litigated at the African Commission. MRG and its partner organizations obtained a successful judgment in 2010. Most of the key provisions of that decision remain implemented, particularly around restitution of ancestral lands and compensation for the rights violations that were adjudicated in their favor in that ruling. There's also the Ogiek case that MRG litigated together with our partner organizations on behalf of the Ogiek community in Kenya. That case, the African Commission actually referred to the African court, and there was a successful judgment that was rendered in May 2017. We're still waiting for the reparations judgment, but Kenya has continued evicting Ogiek communities from their ancestral lands in the years preceding that judgment, and all statements made by the government show that despite this judgment saying that conservation could not be used as a justification for the eviction of Indigenous peoples from their lands, they continue to point to conservation for the reason why their ancestral forest lands cannot be returned to these communities. And there's another case that we're working on now at the domestic level in Uganda, which is an action to enforce a consent judgment that was obtained by the Bennett community in 2005, again recognizing their land rights, and which the government has failed to implement. And as you'll see sort of in litigating land rights cases, at the end of the day, the thorniest and stickiest issue continues and remains to be restitution of ancestral lands, which is the standard generally of what's owed to Indigenous peoples when their land rights violations have been recognized by a court. It's sort of the gold standard, and it's one that regional human rights bodies continue to find in favor of Indigenous communities around their right to restitution of ancestral lands. But at the end of the day, restitution is something that states are continuing to refuse to do. And it causes a lot of problems on the ground, obviously, but also for the legitimacy of the very human rights institutions that have been charged with the protection of human rights, but also ongoing violations that have been quote unquote redressed through legal cases that continue to be sort of remain unimplemented. And so I think at the heart of this pattern of lack of implementation is that states are unwilling to relinquish ownership and control over lands and resources traditionally owned by Indigenous peoples, or to take steps to meaningfully recognize the implication of what the right to self-determination means vis-a-vis the human rights obligations that they have undertaken under the treaties that they have ratified. This dynamic is also reflected in the way that non-state actors, including corporations, interact with Indigenous peoples, because ultimately it is through the state and state institutions that Indigenous rights can be respected, upheld, and enforced against third parties. And you see this against a backdrop where increasingly governments, corporations, and NGOs are paying lip service to Indigenous people's rights in various fora and on corporations' websites and NGOs' websites, but nevertheless still failing to take steps to meaningfully implement these rights in practice. So I'm going to quickly touch on how Indigenous people's rights, and in particular, Indigenous people's rights to land, are not being implemented in the realm of conservation. As I've mentioned, several of the cases that MRG has litigated now are representing Indigenous communities that have been evicted from their ancestral lands in the name of conservation, which is a phenomenon that I think people aren't necessarily as aware of. You know, the paradigmatic case of Indigenous people's rights, you think of an Indigenous people against a corporation or something, not against, you know, a government policy that's purported for the public good. But increasingly, conservation is at in certain parts of the world in particular, is at odds with the implementation of Indigenous people's rights and is increasingly being used as the justification for evicting people, Indigenous peoples from their lands and not respecting their rights. So at the heart of these policies which are being adopted is a very colonial belief that human beings are incompatible with the conservation of the environment. This sort of so-called that the natural world is a wilderness devoid of people, and that therefore the only way to redress the exploitation, the rapacious exploitation of resources and the biodiversity crisis that we are undoubtedly facing is through sequestering ever large swaths of land, fencing them in, kicking anybody that happens to be living there out, and then policing the boundaries, forcefully ensuring that Indigenous peoples and local communities that have often been relying on these lands for livelihood activities do not have access to these lands. And it's often policed by increasingly militarized practices, resulting in lots of rights violations, including the loss of life. And that these policies are being implemented around the world, including under the current global biodiversity, post-2020 global biodiversity framework that's currently being negotiated by the parties to the Convention on Biological Diversity right now, which problematically includes a target that would double the area of protected areas to include 30% of the world, and even calls for us to protect up to 50% of the world. And again, the reason why this is problematic is because the predominant model of conservation, which is a militarized or coercive force of conservation, has a terrible history vis-a-vis upholding Indigenous people's rights. And so, as I mentioned, MRG has several cases now in East and Central Africa where Indigenous peoples are being evicted in the name of this form of conservation. And despite winning several judgments that recognize that conservation cannot be used as a justification to evict Indigenous peoples, states continue to do so. States continue to cite conservation as the reason why they can't restitute these ancestral lands, even though that's what courts order. And ultimately, a lot of the donors in the global north who funds these initiatives continue to cite the need for conservation as the reason why Indigenous rights protections cannot be included at the level of the standards that are being adopted under the post-2020 global biodiversity framework. And you'll see from anybody who's interested about these negotiations that Indigenous rights activists have been calling formally for the recognition of Indigenous people's rights at the level of that target, that 30 by 30 target. They've asked for free, prior, and informed consent, which is an internationally recognized standard applicable to Indigenous people, to be included in the language of that standard, to no avail so far. Obviously, the standard and the framework itself still hasn't been adopted. I think it will likely happen this summer, but ultimately it reveals the fault lines of how these rights are continue today, even by international lawmakers, not to be formally recognized, at least in the realm of conservation. But I'm sure that this is probably reminiscent of other areas of law as well. And I think that one of the reasons why this is so concerning outside of just from the perspective of rule of law is that in the realm of conservation in particular, a growing body of evidence shows that Indigenous peoples are the best custodians of the environment. And in particular, studies that have come out that show that recognition of customary tenure of Indigenous peoples and local communities is actually the most effective way to preserve the environment and preserve old growth forests and have as much carbon remain in the ground as opposed to released into the atmosphere. And nevertheless, even at the realm of like the fora at the international level that are being used to negotiate and address the standards that collectively as a global community we need to adopt to overcome both the biodiversity and the climate crises, not enough attention is being paid to Indigenous rights. These standards are not being included at the level of the commitments that are being adopted by states. And my fear as a human rights practitioner is that if these standards are adopted without us addressing the implementation crisis at the level of Indigenous people's rights, at the end, a lot of measures are going to be taken in the name of conservation or in the name of mitigating the climate emergency that will end up infringing on Indigenous people's rights in a way that's bad for human rights, but that's also ultimately bad for the environment. And I think the case, the Fossen case is an example of this, or how renewable energies or even, are being used again as an excuse not to uphold Indigenous people's land rights. And the same is the case for all of the mining that's going to be required for lithium batteries and all these other so-called clean energies. And so to quickly conclude the problem, because it's a little bit depressing, is to say that if we're really going to overcome some of the major challenges that as humanity, existential threats that as collectively as humanity we face, I really think it behooves us to work on implementation of Indigenous people's rights, but human rights more generally, and to also rethink sustainability, because there's no such thing that's sustainable if it's premised on the violation of human rights. And if it doesn't sort of take some kind of genuine proportionality analysis to think through some of the measures that are being taken. And ultimately that it shouldn't be the communities least responsible for the biodiversity and climate crisis who are disproportionately having to bear the brunt of mitigation strategies that are being adopted. And I think, lastly, in terms of a way forward, I think one way would be to strengthen oversight and monitoring mechanisms around implementation of successful human rights judgments generally. I don't think that will be the end of it. I still think then a lot of advocacy is going to be done and pressure for states themselves to uphold their human rights obligations as vindicated by human rights judgments. I think a lot more work, well, not a lot more work, but we have to continue and double down on advocacy and movement building around this, and to really try and support Indigenous activists who have been at the foreground and the forefront of advocating for their rights, and see how, raising awareness around this issue and really trying to support, upholding Indigenous people's rights could at least try and put pressure on governments. And I mean, another option, but it still needs to be explored and is tenuous, just because domestic legal regimes are not necessarily friendly to transnational litigation or holding corporations accountable for violations that take place in other jurisdictions, but to think through the potential for transnational litigation as well to overcome the implementation gap. Yeah, so that's all, but thank you for having me, and I'll just wrap up.
Well, thank you very much, Ms. Dominguez, for another compelling presentation, obviously really illustrating some of the implementation challenges and gaps when it comes to actually applying these hard-fought legal protections. So as I promised, I want to just briefly bring in Professor Alexandra Xanthaki. As Dr. Solomon mentioned, Professor Xanthaki is, of course, a professor of law here at Brunel University. She's also the current UN Special Rapporteur in the field of cultural rights. Importantly for this conversation, she's a leading expert on Indigenous people's rights in international law, having written extensively on the topic over the course of her career. So, Professor Xanthaki, I'm handing over to you for any comments, reflections, or questions that you may have.
Thank you very much, everyone. And thank you, Colin, from one leading expert to the other, I guess. So what I heard today in these really very interesting discussions and talks, I heard a lot about the implementation of the declaration and how the declaration moves on and how Indigenous rights move on. So not so much on the implementation of the declaration, but also implementation of Indigenous rights. And I think that I can, what I take from the discussions is the ways that the international community and states, but not only states, continue to find ways and obstacles to the implementation of Indigenous rights. So the first way now is maybe a more trendy way of doing things, is by focusing on other interests. So the trendy interest now is conservation. So we heard a lot from the excellent speakers on how conservation is being used to say that, in the balancing of rights, conservation prevails. So this is something that we see now being stopped by the Supreme Court in Norway. I was very interested to hear, and I went and I read the passage where it said that Article 27 ICCPR does not include a test to balance it with other rights. And I think that this is very important, and I'll come back to that. The second way that now Indigenous rights are being curtailed is by not referring to UNDRIP. So I was very surprised that the Supreme Court of Norway, a state that has always been really positive towards, during the elaboration of the Declaration on the Rights of Indigenous Peoples, does not refer, not even once, to the Declaration on the Rights of Indigenous Peoples. So, and this has an effect on Indigenous rights, but this has an effect on human rights, because international human rights are not just the legally binding, the provisions that are in the legally binding instruments. And this is very worrying. So I keep thinking, if the Supreme Court of Norway does not refer to UNDRIP, which is not just a declaration, but it's a declaration that we all say that it has, at least in parts, customary international law status, then what can we expect from other domestic systems? And the third way is by seeing Indigenous rights as completely separate from any other human rights. So what Rauna said at the beginning, that the UNDRIP does not refer to women's rights extensively. By the way, during the elaboration of the declaration, Indigenous women who were in the room actually very explicitly said that they did not want the situation and rights of Indigenous women to be discussed, and we all respected, of course, their views. But it's very interesting how now by focusing only on the text of UNDRIP, we can just say, oh no, Indigenous women have very limiting rights. But if we see the UNDRIP together with all the other human rights tools that we have, maybe then we will go to more progressive understandings and interpretations. So essentially, I see a new attempts to do exactly the same thing that states and corporations have been doing by essentially maintaining and trying to maintain the elites. Whether the elites are the states, whether the elites are the dominant groups, or whether the elites are the now new elites, the indigenous elites within the states that oppress the women. And I think that now gradually, as the declaration becomes more and more central in human rights, we have to bring that up, and we have to say that, we have a marginalized group within the marginalized group that we have to focus on, as some of our speakers are doing with great success. So I learned a lot from these three talks, and I'm really looking forward to the discussions. And I just have to note that I couldn't I couldn't resist thinking that Colin's article on the murdered women in Canada is so much at the core of the discussions that we've been having today. So maybe at some stage, Colin, maybe in another event, could talk about his research on these issues. Thank you very much.
Thank you, Professor Xanthaki, for those very insightful reflections, really bridging everything together that we've discussed today. I'm cognizant that we're 22 after the hour. I'd love to keep going with this discussion the rest of the afternoon, but perhaps I'll just start by giving the other panelists an opportunity to reflect and respond if they wish to anything that Professor Xanthaki said. Otherwise, I'll continue to monitor the Q&A for a couple more minutes.
Yes, we can give, indeed, we have a question already, Dr. Luoma, and the people on the audience can continue streaming their questions to all of us, the panelists, to Professor Xanthaki.
Terrific. Well, maybe I'll start with the question in the Q&A. This is from Isabel. Thank you very much to our panelists today. It's been a very stimulating and interesting session. One might be tempted to see Indigenous peoples' rights as natural allies of the climate change movement and campaign, given that Indigenous peoples represent a small percentage of the world's population, and yet they play a significant role in protecting the world's biodiversity, hence the environment, and arguably in contributing to slowing climate change. But as both Lara Dominguez and Dr. Cambou compellingly discussed, green energy, conservation policies, and climate change may clash with Indigenous peoples' rights to the detriment of the rights of Indigenous peoples. So the question is there room for hope? Can any strategic alliances be made between climate change and Indigenous peoples' agendas? In the panelists' views, what, if any, may be other more positive policy, legal, and campaigning opportunities? So I think that's quite a relevant question for our conversation. I don't know if Dr. Cambou, if you have any initial thoughts on that, we can obviously turn to Ms. Dominguez and others.
Yeah, thank you again for the brilliant talk from Lara, and also for your comments, Alexandra, which are really insightful. But to answer this question, I think I want to be optimist. And yes, there is reason for hope for multiple reasons. The first one is that in what crossed my mind is in fact in the court case of Fosen, the court established that the interests of renewable energy should not be promoted at the expense of Indigenous people rights. It's not a large section of the judgment. Nevertheless, it is mentioned, and the court elaborate upon that. So I see this judgment as a proof for hope, in the sense that, yes, there is an emergency crisis with respect to climate change, but this doesn't mean that the human rights of Indigenous people should be violated. And another, more pragmatically, I think there is in fact room for hope, because if we look at the Fosen case and other major cases, Indigenous people were often at the front line of those cases to defend their right. But what we shouldn't forget is actually environmental activists were also opposing those projects. So in practice, I think there is room for hope, because those groups actually formed an alliance to oppose those projects. The problem with those projects is that they are large scale, and their impact on biodiversity is actually neglected. So what we see on top of it is actually an opposition between the climate emergency discussion and the discourse on how to protect conservation. So altogether, this is really like often sparkling basically opposition between biodiversity on the one hand and climate on the other, and we need to put those agendas together. And I think this is what Lara was mentioning. So yeah, so this is what crossed my mind seeing this question. But yeah, I leave the floor.
Thank you. I'll let, it looks like Professor Xanthaki has her hand up, even though she has my name underneath her screen.
Yeah.
But,
yeah, Colin, shall we stick to Alexandra? I mean, and forget about the Professor Xanthaki for a bit. So what I wanted to say is that, you know, what I find is that it's really, the big challenge is to convince the domestic society about the importance of Indigenous rights, because very often we see that in the domestic societies, the idea is that, well, you know, the general interest of the state, the general interest of the majority should prevail. So I was wondering whether Laura, you have seen that, and whether this has been an obstacle in your litigation. So it's not the state per se; it is the society that resists to the implementation of Indigenous rights, and whether you think that civil society can help in some ways. And of course, the same question applies to Dorothee as well.
So I've seen, obviously, the state use the general interest. And in some countries, you also get some of the general public. I don't know if, there are a couple things that I'll say about the general public. I think that there's a general ignorance about how a lot of conservation projects impact Indigenous peoples, and also the relative bad track record that these coercive conservation models have vis-a-vis Indigenous custodianship. So a lot of the time, state-managed protected areas do not do as well, are much more costly than just recognizing and enforcing customary tenure rights of Indigenous peoples. And I just think that there's a general ignorance about that. And so at the general public level. And so you have a lot of members of the general public, maybe in theory, supporting a protected area, or saying, for example, well, the Mau forest can't be returned to the Ogiek because there's been a lot of destruction, and ultimately there's a lot less rainfall now. So we really need to protect the water catchment. And what they don't understand is how a lot of non-Indigenous communities have been the primary encroachers, that a lot of the destruction of the forest has happened under the Kenya Forest Service watch. And so there's a question about how effective is the Kenya Forest Service as a custodian, and the fact that in almost every protected area where MRG is representing a community against the state, there are allegations that it's the forest rangers themselves who are engaged in destructive practices. Because there's also just, you have a question about who's allowing for the illicit, illegal resource extraction to take place in protected areas, or sometimes it's the very state that gives the license to a mining company to go in and mine in a protected area, or a logging, or et cetera, et cetera. And so I think that in that sense, like raising awareness around that issue, I think could really help to gain public support for the implementation of Indigenous people's rights. Having said that, I do think we need to be cautious about the advocacy around that, because I don't think it should be, well, the reason that we need to implement Indigenous people's rights is because they're the best custodians. I don't think that's the case. I think that, you know, there are other important reasons why. And so to sort of instrumentalize Indigenous rights in that way, I think it just has to be done cautiously, I think, in how the advocacy is done. But I do think that raising public awareness around that issue could go a long way, both in raising public support, but also in drawing out some of the natural alliances, I think, that can be made between the environmental movement and Indigenous peoples. And it's also true, as Dorothee was saying, that a lot of environmental rights activists have also been part of the groups of civil society that have opposed projects and you know, have supported Indigenous peoples in the advocacy that they're doing. So I think that there's definitely that potential, and that's certainly the hope. I think at the end of the day, though, it would be also important in alliance building to ensure that non-Indigenous civil society actors or non-Indigenous supporters of some of the causes that Indigenous peoples have to advocate on or champion are ensuring to be respectful of Indigenous people's rights to self-determination, and not to push them to water down their demands to meet other policy goals that some of these civil society actors may have. And so I think there's definitely potential, but of course, navigating in practice how some of those alliances form and how those demands for justice are articulated, of course, is going to be where the rubber hits the road, I think.
Terrific. Dorothee, do you want to make an introduction?
If I may to pick up on something that Lara was mentioning, and I cannot agree more with Lara. And in addition, what I wanted to add is that it's in the case of the Nordic countries, I think it's not a problem of ignorance, but neglect. Because what we see is that environmental impact assessments were actually conducted, which led to conclusions that were in between, so to say. Those environmental impact assessment concluded that the fossil project will have negative consequences. But then the argument of the authority was to question whether or not this impact was so significant that it would trigger a violation of human rights. And already from the start, we see a power relationship game that began, because obviously, if the governmental authority are challenging the conclusion of environmental impact assessment and questioning whether or not the impact will have a significant effect that trigger human rights violation, obviously indigenous community are meant to fail. So I think in the case of the Nordic country, we really need to re-emphasize the standard of indigenous people rights, because they are not implemented correctly. They are enshrined in the legislation, but they don't even go far enough, I would say. And I think there is like some twist and to make in that regard at the national level. And for sure, governmental authority are very aware of this legislation. They are just compelled to implement them poorly because other interests are at stake, and in that case, climate emergency.
Alexandra, would you like to go ahead?
Yes, that's really interesting. It's a really interesting discussion. So my next report as the UN Special Rapporteur in the field of cultural rights is going to be on development and cultural rights. And what I have seen as I have been working with this report, is that it's not just the states. So we keep talking about the states and we talk about corporations, but UN agencies have at times, they have very limited understanding of, and satellite bodies have very limited understanding of indigenous rights and what should be done. And we tend to be very critical towards financial bodies, so towards the World Bank and IMF, which we should, and well done us. However, the only way is to start engaging with them. And I have to say that the World Bank has, at least in theory, done some steps to address rights of indigenous peoples in their funded projects. So I think that I wonder whether our speakers have seen that this is a very dangerous trend as well, that, in trying to convince the states, it is their donors or the people that are supposed to implement the rights that are the ones that don't know about the standards on indigenous rights, or treat indigenous rights as a little paragraph at the end of each document.
Well, I'm sure that Lara and Dorothee may have responses to that. So I will turn it over to both of you, and maybe that will serve as a good way to conclude our conversation today. Lara?
So thank you for raising that question, Alexandra. I mentioned NGOs and donors a little bit in passing in my presentation, but didn't have a chance to really get into that issue, but it's a major issue in the realm of conservation. So in the realm of conservation, we're often, protected areas in particular, we're often talking about both like government development agencies from the global north who are pushing these agendas, as well as global conservation NGOs like WWF, Wildlife Conservation Society, any number of global conservation NGOs who are themselves complicit in the commission of human rights abuses in protected areas. And there was a BuzzFeed News reporting that came out documenting systemic human rights abuses that are taking place in protected areas that WWF co-manages and or supports. And from the experience that we have in the protected areas in Africa with the communities that we're working with, these organizations are just as complicit. And UNESCO, for example, is another entity that is often sort of attributing or designating World Heritage Site protections to indigenous lands without consulting indigenous people, and who are themselves, along with the International Union for Conservation of Nature, lobbying governments to implement and enforce and extend protected areas in a very militarized way, sort of saying, well, you want to keep your, this recognition of this site as of special, significance or whatever it is. And because tourism is a big draw for a lot of these areas, at least in Africa, a lot of countries, for example, this is going on in Tanzania right now, where not only were the Maasai already forcibly evicted, or at least hoodwinked into leaving and relegating their lands in the Serengeti in exchange for other settlement areas. Now, UNESCO and IUCN are actively lobbying Tanzania to remove them from the lands that they were given as in exchange for the lands that were already taken from them, using the pressures on the so-called Serengeti as the reasons why. But then I have these questions, which is like, when indigenous peoples were owning and custodying these lands, there weren't these issues. So why do we keep doubling down, citing the failure of state protected areas to actually conserve the environment as the continued reason for why indigenous peoples need to keep being dispossessed? And just to quickly on UN agencies other than UNESCO, UNEP, I think, had, there's the Mesojak project in the Republic of Congo, where similarly UNEP
Which project?
The Mesoja project in the Republic of Congo, where UNEP acknowledged that it failed to do an environmental and social impact assessment before deciding to work on this conservation or protected area. And so I think that's the thing, is that in this area, everyone's like, oh, well, we thought conservation was good, so we didn't have to do that. And so I think at the end of the day, this is something that increasingly the lack of environmental and social impact assessment in the realm of conservation is really serious. And I think that the structures and the systems that are in place to fund these protected areas around the world are very similar to other development projects and should be assessed on the same lens. And that in that sense, I think it was John Knox who was one of the experts who worked on the independent panel to sort of assess WWF's wrongdoing, basically said that it should be the business and human rights framework that applies to these NGOs just as much as it would to corporations. And at the end of the day, this is how they function. They have, their own guidelines and standards that pay a lot of lip service to indigenous peoples, and they have their own very well entrenched PR spin machines. But at the end of the day, they're not actually interested in changing their practices. And very few people who have to implement these projects on the ground know anything about indigenous people, or even when they do consultations, they have no idea how to apply the free, prior, and informed consent standard. But at the end of the day, they're not that interested in doing that in an efficacious or fulsome way, because at the end of the day, it limits their power. It would then limit their funding. The funding wouldn't flow to them anymore. It would be communities themselves that would be given funding and autonomy to decide which conservation policies were being adopted in what way on their lands, and the entire dynamic would be different. So thanks for that question.
Dorothee?
Yes, thank you for that question, because I really think the other part of the issue is, of course, what to do with responsibility of private actors, investment fund, businesses, and of course that would require an entire presentation. But my point would tie with the responsibility of Western businesses or Western investment funds. Because what we see is, on the one hand, renewable energy company operating in the Nordic countries operate under the national legislation of those states and obey by those standards. And when they find out at the end of the process, such as in the case of the Fosen case, that actually their project is in violation of human rights, it's quite a surprise, because they would expect that Nordic law is actually up to the standards of human rights law. So this poses the question of the responsibility of those actors other than the responsibility of the states. And there is a lot of work being done at the moment on the human rights due diligence of companies. And I think we need to invest more time into articulating what does human rights due diligence means in relation with indigenous people. This is a project that I've started to work on, but it is really crucial, because if we wait until states actually change their legislation, it's in fact too late, as we see. And the other point I wanted to raise is in relation with Western Investment Fund, because we see that the World Bank, as you mentioned, theoretically at least, has been doing a lot of work with indigenous people rights, but a lot of other investment funds, national funds, are actually neglecting this aspect. And one case that comes in mind is the recent project in Kenya that was built in Lake Turkana. It's one of the largest renewable energy projects in Kenya, and it has raised a lot of controversial issue in relation with the question to know whether or not respect for free prayer and informed consent was secured. And this project was funded by FinFund, which is one of the Finnish state, the major state-owned Finnish investor. But what was interesting is that they funded, they participated in the project after the World Bank withdrew. So I don't know the specific of the project, but this raised also some questioning. So in any case, what we see is that we have a legal gap, loophole that we need really to address, especially in relation with the extraterritorial obligation of Western actors and private actors more than other state actors.
Perfect. I think this makes serves as a good point to conclude our discussion today.
Dr. Luoma, just to ask, to have a question in the Q&A section, maybe that we have to answer, because
I'm sorry. Yeah, let's just see if we can cover this quickly, because there's just one in the Q&A. The final question from Helene is, what role do the voices of scholars who are themselves Indigenous play in scholarship on Indigenous rights? Could we do more to include Indigenous voices as a way of further decolonizing scholarship? If so, and what benefit might this have? I'm not sure if any of the panelists would like to respond to that question. It might be one that would have been better served for Rauna before she left, but if anyone has, it looks like Alexandra would like to comment.
I think that absolutely, there's always more space for Indigenous voices, but I think that my concern is that by adding and by emphasizing and focusing only on Indigenous voices in Indigenous rights and in the Indigenous cause, we make it even more into a niche area. And already people are talking about a niche area, when really it is becoming very central to the human rights system, because it has to do with marginalized people, etc. So my worry, what I would say is that I would be the one advocating for the inclusion of more non-Indigenous voices and more non-Indigenous advocates in every single aspect of Indigenous rights, because I think this is when the real decolonization is going to happen.
Thank you for that. And does anybody else on the panel want to weigh in on that, or shall we leave it there? Seeing nothing, I think this concludes our discussion today. I just want to thank everyone, the audience, but particularly the speakers today for sharing their time and their expertise in what I think was a really, really interesting and engaging talk. So if there's nothing else on the
and I would
agenda,
like only for my part to thank again also the chairperson, Dr. Luoma, the colleague, and Professor Xanthaki, and of course the panelists for joining this BUL International Law Group event, and to remind the audience that our next BUL International Law Group event is on June 13th. It's about public health and international law. It's going to be chaired by Dr. Pin Lin Lau. And with this also, I thank you for my perspective and wish everybody a nice afternoon.
bye everyone.
Bye, thank you so much.
Thank you very much for the invitation.